Trial by jury was very important to the Founding Fathers, so important that it was originally secured as a right in the original text of the Constitution. There might be some cases where a defendant would want to waive the right to trial by jury, though. In this screencast, we'll talk about your right to trial by jury in accordance with the Code of Criminal Procedure and under what circumstances you may waive that right. According to the Code of Criminal Procedure, the right of trial by jury shall remain inviolate. Inviolate means it shall not be infringed upon or impaired. While the right to trial by jury is inviolate, there are some instances in which a defendant may want to forego the trial. One particular situation is when the defendant wants to agree to a plea bargain. Plea bargains are responsible for resolving around 98% of criminal cases and involve a defendant pleading guilty in exchange for the prosecutor seeking or recommending a pre-agreed sentence length or type. Plea bargain or not, should a defendant want to waive their right to trial by jury, the Code of Criminal Procedure outlines how and when they may. The Code of Criminal Procedure states, all defendants may waive their right to trial by jury unless they are charged with capital murder and the state intends to seek the death penalty. In all other cases, waiver of trial by jury must be made in person, in writing, in open court, and with approval of the judge and consent of the prosecutor. In this case, such as during a plea bargain, if all parties agree, consent of the court, meaning the judge, must be on the record, and consent of the prosecutor must be on the record and in writing before the defendant enters his plea. In a capital felony case where the prosecutor will not seek the death penalty, in other words, they're seeking life without parole, the defendant may waive the right to trial by jury with consent of the prosecutor. All other defendants, with or without an attorney, may waive their right to trial by jury unless the defendant is charged with a felony and the defendant is not represented by a lawyer, in which case the court will appoint an attorney prior to accepting the waiver. So here's a summary. You can waive your right to trial by jury, but the case must not be a death penalty case, and the judge and prosecutor must consent, and if the charge is a felony, you must be represented by an attorney. There's one more right a defendant may want to waive in order to speed up the process, particularly in the case of a plea bargain, the Texas right to be indicted by a grand jury for a felony. A defendant may waive the right to be accused by indictment unless it is a capital felony.